Welcome to the series of Basics of Interpretation of Statutes. In this video, we will talk about the types of subordinate laws. In the last video, we have discussed the difference between supreme law and subordinate law. If you want to learn about it, you will find the link in the description box. Now, subordinate laws are those laws which are made by the executive. Now, the main function of the executive is to implement the law and not to make a law. Now, the executive performs the function of making a law only if the legislature delegates his power of lawmaking to the executive. But the question arises, why would the legislature would delegate its lawmaking power to the executive? There are three major reasons for it. The first one is that it is not possible for the legislature to make laws on every subject because whenever the legislature makes a law, it takes a lot of time because every bill needs to be introduced in either house of the parliament or state legislature, and then the bill needs to be passed by that house where it is introduced, then it needs to be passed by the other house, and then the assent needs to be obtained from the president or governor as the case may be, and the whole procedure takes lot of time. The second major reason is that the legislature does not have expertise on all subjects. For example, on the matters of atomic energy, environmental matters and others. On this, the legislature does not have expertise. So it is better that the expert people only make laws on these subjects. Therefore, the power is delegated to the executive. Now, the third major reason is that there are certain situations where emergent actions or immediate actions are required, such as if there is a law and order problem at the ground level, or where there is a case of pandemic in a particular area, or where a huge number of people crowded at one place and creates a law and order problem. In such a situation, immediate action is required, and if in that situation the legislature start making a law, in that case it would be difficult to tackle that situation because it needs immediate action. Therefore, the legislature delegates power to the executive to deal with such situations. Now, the type of laws which a subordinate can make. If we refer Article 13 of the Constitution, it talks about the term law. Now, it refers to acts, rules, regulation, bylaws and customary laws. We have already discussed about the customary law in the last video. If you want to learn about it, you will find the link in the description box. In this video, we will talk about act, rules, regulation and bylaws. Acts are the laws made by the legislature itself, and the procedure is same. That is, the bill needs to be introduced, passed by both the houses, and then the assent needs to be obtained from the president or the governor as the case may be. And the law made by the legislature is called act. Example of it is Hindu Marriage Act, Juvenile Justice Act 2015, Protection of Children from Sexual Offences Act 2012 and others. Now, this law is called supreme law. Now, if we talk about subordinate law, it covers majorly three types: rules, regulation and bylaws. These three terms are used as synonyms, but there is a difference between the three. Now, whenever any act is made, it lays down the substantive part of the law. Like if we talk about Juvenile Justice Act, it prescribes that if any child below 18 years commits an offence, how that child needs to be tackled, how the child between the age of 16 to 18 years and committed a heinous crime needs to be treated. But with regard to the implementation of the act does not talk about and gives the power to the executive, that is the state government or the central government as the case may be, to make rules for the implementation of the act. So if a law is made by the state government or the central government, for the implementation of the act, these are called rules. Now here the central government or the state government means the concerned ministry. If we talk about ministry, if the law is regarding children or women, then here the central government or state government means Ministry of Women and Child Welfare. If the law is with regard to commercial matters, for example, company law, sales of goods act, contract act and others, in that case, the central government or the state government here means Ministry of Corporate Affairs at the central level or at the state level. because the concerned ministry form part of the executive. Now, under acts, sometimes certain authorities are created. Now, to regulate the internal matters of the authority, the power is given to the authority itself to make a law. And if the authority makes that law, it is called a regulation. For example, under the Juvenile Justice Act 2015, authority is created, that is CARA, C-A-R-A, which means Central Adoption Regulatory Authority. Now, this authority is given a power to regulate its internal matters like when the meeting is to be held, where the meeting is to be held, and how many members needs to be there, and other matters. Now, the law with regard to the internal matters made by the authority created under an act is called regulations. Now, the question arises whether it is mandatory to have rules and regulation under every act. The answer is no. It is not mandatory that every act should have rules and regulations. It depends upon law to law. Now, the third category of subordinate law is bylaws. Now, to understand bylaw, we need to understand the concept of local authority. Now, we all know that in India, we have a quasi-federal structure. That is, we have a central government and then the state government. But we also have a third level of government, that is local authorities. These authorities are created for the administration of local matters. Now, in urban areas, we have municipalities and municipal corporations, and in rural areas, we have Gram Sabha, Gram Panchayats, Jila Parishad, and others. Now, these authorities are also given a law-making power to perform their function in a better manner. Now, the example of it is that we all have heard that the local authority has made a law to segregate the garbage into wet and dry category. Secondly, during summer times, the authorities issue a direction not to wash cars with running water. These are the example of laws made by the local authorities, and it is called bylaws. So, bylaws are the laws made by the local authorities to perform their function in a better manner. So, act is a supreme law, whereas rules, regulation, bylaws are the subordinate laws. I hope you liked the video. For more such video, please like, share and subscribe.